Welcome to Hull on Estate and Succession Planning, a series of podcasts hosted by Ian Hull and Suzana Popovi-Montag that will provide information and insights into estate planning in Canada from the offices of Hull Estate Mediation in Toronto. Here are Ian and Suzana.
Hi, and welcome to Hull on Estate and Succession Planning. You're listening to episode 131 of our podcast on Tuesday, September 23rd, 2008. Hi there, Ian.
Hi, Suzana. How are you doing today?
I'm well, thank you. How are you?
Just terrific. We are thinking through this will challenge process, and we're trying to hopefully take it beyond the typical will challenge and talk about some sophisticated steps that are often involved. A, because they're good, they're helpful, hopefully for people who want to get into these will challenges, but B, it's helpful to know what you get yourself into. And this is part of it. We talked about our last podcast, getting a retrospective opinion. This is it's not uncommon, but it's also a very expensive process. You have to pick the right expert. You have to make sure the report is clear and concise in a way that a judge is going to receive it well, because judges are people too. They don't want to see a 20-page report full of, esoteric medical terms that nobody can follow. So there's a strategy that within the strategy of bringing that on. Let's talk now about how we deal with the question of undue influence, because we described in our last podcast what undue influence was, and that is coercion, and that is the arm twisting. So let's talk a little bit about what do we mean by that, and more importantly, how do we prove it?
And really, the allegation of undue influence is that the testator, at the time that he or she created their will, was not doing it on their own free and volition. And so Ian classically describes it as this arm twisting. The judges call it that in a lot of cases as well. And the idea there is that someone has influenced you to do something that you would not otherwise have wanted to, or at least not to that extent. So maybe, yes, you did want to provide for little Johnny, but not to the extent of your full estate and to the exclusion of your daughter Betty. So that's the kind of idea when we say undue influence. Certainly there's a level of influence that we all have on our family members. The question is, when is that influence undue, in the sense that it could compromise your capacity to make a valid will?
And the classic example in the case law of what is undue is when you sit across the table from your mother and you say, if you don't do what I say, I'm going to put you in a nursing home. That's a graphic and obviously, hopefully, never said illustration. But in our world, we do see it, and we see that it's being alleged to have been said, and that's a classic undue influence. The thing that really we're troubled with undue influence is that the nature of the claims and the allegations are typically so volatile. They're some people say mean-spirited, because if you're going to unduly influence, you have probably behaved very badly. And so one side of the case is going to say you behaved very badly and spell it out, so it looks like allegations of egregious behavior, and the other side is going to have the complete opposite. So just the nature of the evidence itself turns this litigation into volatile, typically aggressive litigation in and of itself. So that's an important strategy point that we always like to walk through our clients with, saying you go down that road of alleging undue influence, you create a new environment, and sometimes a very distasteful litigation environment. So, sorry.
And I was going to say, and it's very hard to go back. Once you've done that, you've sort of crossed the line. It's very hard to take that back. When you're dealing with family members, you're dealing with loved ones, these are really nasty allegations. Many times, they don't necessarily have to be, but most of the times we see that they are. And so it becomes a he said, she said situation. And by virtue of the allegation itself, that someone was unduly influenced, one of the biggest concerns, or one of the biggest issues that we face as lawyers, is getting proof of that undue influence.
Absolutely, and that's really, so first of all, we don't like to go down that road, because you're going to have to say some very nasty things or defend very nasty things, and you're going to create a volatile litigation environment. But the second point is exactly what Suzana said, and that is that we're stuck with the legal parameters. I mean, the concept of undue influence has been around for hundreds of years. We're stuck with the legal parameters, and the 2 points within that category are this. One is that to allege undue influence is a very tough case to meet. The courts have said it is the highest of expectation to prove that there was undue influence. The second component is the source of the undue influence has to come, and I may be overstating it, but basically has to come from third-party, non-participant evidence. And what do we mean by that?
Well, Ian, what we're suggesting there is that when you make an allegation of undue influence, then your evidence in support of that will be viewed, if it's directly your evidence, probably by a judge, as self-serving evidence. Well, of course you're going to say that you saw this, or that this happened, or that that happened, because that helps your case. But if you want to add credence to your allegations, you've got to have the evidence of someone else, someone who's not vested in the process or the result of the process, who's going to say, yes, I saw that kind of behavior being exhibited. I saw these threats being made to the testator. I know that this is what actually happened.
And a classic example, follow through with that, is that we talked about the son sitting across the table from mom saying, you do what I say, or I move you into an old folks home or a nursing home. That threat is seen by the next door neighbor who happens to be over at the house helping out this nice elderly individual. And that neighbor has no vested interest, is a third-party source, and is someone that what we call corroborates the evidence. And so we remember that we've got very difficult expectations. The court's undue influence is akin to fraud. It's like you say that, you're basically alleging fraud. So the courts say there's a very high standard on those who want to pursue that claim. Part of that high standard is that you need corroborative evidence. And in that component, the third component is, Suzana, what are we getting at when we say corroborative evidence, and why does that matter in estate matters?
Well, corroborative evidence, of course, Ian, is evidence that's going to prove additional evidence that you have, so the allegations that have been made in support of the fact that someone was unduly influenced. And one of the key things with this type of evidence, of course, is that if you are, in fact, an undue influencer, you're probably smart enough not to be doing it in front of others, so that you don't have these third-party witnesses or individuals who overhear these threats being made, don't see this kind of behavior being exhibited. And so it's very difficult, we tend to find in these situations, to come up with this corroborative, this additional evidence in support of the allegation.
Absolutely, because it's so difficult, though, it's also a non-starter if you don't have it in many cases. And that's because the courts have sat back and said, if you're going to allege that certain things were said by someone who is now dead, you have to source that beyond your own evidence. You have to buff that up. You can't just say that. You can't speak for the dead, so to speak. And that is really, which is an old, I mean, it's a great old common law tradition and an evidentiary expectation that you corroborate. When you're going to put words in the mouths of a dead person, you have to corroborate it.